Good afternoon. I'm Judy Woodward, the History Coordinator of the Ramsey County Library, and it is my great pleasure to welcome you to this final Tuesday Scholar event. Our speaker today is Timothy Johnson, who will address the topic, A Look at the Supreme Court Term 2022-23. Timothy R. Johnson is the Morse Alumni Distinguished Professor of Political Science and Law at the University of Minnesota, and he is a nationally recognized expert on U.S. Supreme Court oral arguments and decision-making. Today's program is brought to you through the co-sponsorship of the Osher Lifelong Learning Institute of the University of Minnesota with the financial support of the Friends of the Ramsey County Libraries. We are deeply grateful to these organizations. Thank you very much. And now let me turn things over to our speaker, Tim Johnson, on the topic, A Look at the Supreme Court Term 2022-23.
Judy, thank you so much for having me, and thank you all for coming again. This is one of my favorite talks to give with this group, reviewing things that the Supreme Court has done over the course of a term, and then, of course, interacting with you all as hopefully you will have questions at the end. So I will share my screen with you all, and we will go from there. So here we go, and you will see me from time to time probably moving around the camera and moving around the bottom bar to make sure that you can see everything properly on my PowerPoint slides. And so let me just begin with a roadmap for today's talk. And that roadmap, I'm going to begin with some statistics about the term as I have in years past, just so you can get a sense of what has gone on with the court. Despite the fact that the term is not yet over, the justices have several and several of the most important decisions still to hand down, but I can give you the most up-to-date statistics about what has gone on with the court. And then I'll cover a variety of major issues, the most important cases that the court has decided this term so far. So I will cover free speech. I will cover the decisions the court has made, two of them in particular on Native American law. I will talk about the ADA. I will talk about the Alabama redistricting case, executive agency power between court and Congress, and then which is something that I haven't done very often because Minnesota has not come to the court very often in past terms. I will talk about the three cases that are related to the state of Minnesota. I will then talk about major cases not yet decided, and then I'll give you a short preview of what is to come beginning in October of this year, because like most major sports associations now, the court doesn't take all that much time off. It's probably clear that they are going to go through the end of June, if not bleed over into early July, as they have the past couple of terms, and then they are back to work on the first Monday in October. But let me begin with some data, and I was trying to figure out what I wanted to label this first slide, and I really came up with this, that perhaps the justices are not citing as many cases as they were in the past, and this seems to be what has been happening, although although the 2022 term is not different than any of the most recent past of the Roberts Court. So if we look back to the 2018 term, it seems like eons ago because it was pre-COVID. We've got two terms, or 1.5 terms pre-COVID. If I begin just 5 terms ago, the court decided 74 cases. And even then, scholars were wondering why the Roberts Court had dropped to so few cases. We then come to what is essentially an all-time historic low for the justices, deciding only 53 cases during that COVID shortened term that ended in July of 2020. They jumped back a little bit in the 2020 term. We're still in the midst of COVID with 58 cases, 58 again in 2021. And in fact, they increased by 1 case decided this term. Now that is orally argued cases, as well as cases that are decided on the court's emergency docket, or what folks like to call the shadow docket. And so while it seems like the justices really are deciding few cases, and if you compare to the mid to late Berger court or even the early Rehnquist court, it is certainly clear that the justices seem to be doing, if you will, less work, when in those eras that I just mentioned, the justices were deciding upwards of 175 cases per term. And even in the early Rehnquist courts, somewhere between 100 and 130 cases per term. And so it seems as though the load has decreased quite a bit. The justices would argue that they're simply making sure that they are leaving room on their docket to decide only the most important cases and are trying to keep as many frivolous cases off of the docket as humanly possible. But what we do know for certain, even if over the past half decade, the justices have not decided that many fewer cases since those 74 in 2018. They certainly are taking a much slower pace in their writing of those decisions. This term, the first decision did not drop, if you will, to use a term from millennial slang, until early January. And it was the first time since 1946 that the justices had not handed down a decision in December. And you can take a look at the figure here. These are all of the different terms. So for instance, the blue dotted line is October term 2016, but take a look at the red line, which is October term 2022. And we have 0 cases decided all the way through early January, and then it comes out at a drip and a drip and a drip at that case as well. In fact, there were only 7 of the 59 cases decided by the end of January of this term, with 18 by June 21st, which is just under a week ago, there were still 18 cases remaining for the justices to decide. As of the 26th, which was just yesterday, there were 11 cases still to decide, and there are still 8 cases pending. And while the justices are going to issue opinions again on Thursday, so just 2 days from now, the chief did not indicate that that would be the last day of opinion announcements. So you can probably expect somewhere between 3 and 5 opinions on Thursday, and then somewhere between 3 and 5 opinions probably next Monday. The problem with that is that Tuesday is the 4th of July. Oftentimes Monday is seen as a holiday for many, although it's not a national holiday. So I could expect the justices maybe to go through Monday. To stop that, I suspect one other hypothesis is that the justices will have those 8 cases decided and handed down partially Thursday and then partially on Friday of this week. Only time will tell. Now, the other interesting data that I wanted to talk about before, in fact, we turned to, or I turned to the cases, major cases in the issue areas that I discussed, is the vote breakdown, because we talk about this idea that this court has become so incredibly contentious, not only from the leak with Dobbs last year, but with the ethics charges against Justices Thomas and Alito and the Chief Justice, as well as others who have had issues that have really brought to the forefront this idea of the justices having a major legitimacy problem. And if you look at data from almost any polling data that comes out, it is very clear that the Supreme Court, which has always enjoyed much higher approval ratings than Congress or the presidency, is really hitting an all-time low. What is the reason, therefore, that I'm talking about the voting breakdown is that there is actually some idea that maybe the negativity outside the court has not fully harmed the court. Fully 25 out of all of the decisions that have already been handed down are 9-0 decisions. Now, none of those are necessarily very controversial cases, if you will, but it still suggests that on major portions of the law, over a large swath of the justices' docket, all of the justices across the board can agree. Again, think about that. 25 of the cases handed down so far, with only 8 left to be handed down, have been decided unanimously, all the way on the left from Justice Ketanji Brown Jackson to the farthest right with Justice Clarence Thomas. Now, one might suspect that with the 6-3 conservative majority we have on the court, that in fact, once you see cases with dissents, beginning with 8-1 decisions, you're going to see most of those dissents being from the liberal bloc. And while that is true in some parts of the breakdown, it's not true for all of them, especially in 6-3 and 5-4 decisions. There have been also 4 8-1 decisions, and you will note that those are sort of spread out, if you will. Two of them expectedly would be from Justice Clarence Thomas. He is sort of that lone wolf on the bench who's more willing than almost any other justice over the last decade, and maybe even a little more than that, to write on his own. But we also have a lone dissent by Justice Neil Gorsuch and one lone dissent by Justice Ketanji Brown Jackson. Now let's jump to the 7-2 decisions. And in fact, there you go. You've got the one by Clarence Thomas, Jackson, and the one, and in fact, I have AS. I don't know why I have Antonin Scalia there. It's actually Neil Gorsuch, and that was clearly a typo as I was writing this. 6 7-2 decisions have been handed down. And again, these are, if you will, this is where you get some very interesting results in terms of there being pretty hardcore dissents, mostly from the right. But let me just highlight 2 first. One, we've got a dissent that was written by the Chief Justice and Justice Elena Kagan. And you would think that those would be strange bedfellows or strange partners on a dissent, but they teamed up on a dissent this term so far already. And then you would assume that if you're really going to get 2 justices dissenting, that they would most likely, given the ideological makeup of the court today, they would be the 2 most liberal justices. And you get that here with Justices Sotomayor and Jackson. But then you get the unusual 2-person dissenting coalitions, and that is conservatives. So you get dissenting coalitions twice with Justice Alito and Justice Thomas, once with Justice Alito and Justice Gorsuch, and once with Justice Thomas and one with Justice Coney Barrett. And that suggests that that's really strong held thought that the conservatives were going to be able to do anything that they wanted at the bench, especially after what we saw them do with abortion rights and Second Amendment rights last term, that would be an unbreakable coalition. But once you start getting this idea of conservatives dissenting with one another and being unhappy with the liberals teaming up in most of these cases with the Chief Justice and Justice Kavanaugh or some grouping thereof, it indicates that there are issues and there are areas where there are going to be breakdowns in that very hardcore conservative coalition. Now let's take a look at 6-3 decisions. There are 6 of them. And you will note that only one of them is what you would think would be usual, this Sotomayor, Kagan, and Jackson dissent. But all of the rest of these dissents come from the conservative majority again. And again, that 6-person conservative majority, but 3 in any one of these 5 cases who are suggesting that they disagree with what the majority has done. You get an Alito, a Gorsuch, and a Kavanaugh, a Thomas, and Alito, and a Gorsuch, a Chief Justice, a Thomas, Alito, and then again, you get a Thomas, Alito, Gorsuch in part, another Thomas, Alito, and Gorsuch, and Coney Barrett in part. That's why I've got 4 of them in there, even for a 6-3 breakdown. And so again, you get conservatives who are really concerned about decisions. And then finally, what we consider the most contentious decisions, we have 9 5-4 decisions, but you're also going to be surprised with some of these because there are 6 odd coalitions. Take a look here. We've got a coalition where Gorsuch signs on with the 3 liberals. We actually have 2 dissents where Thomas signs on with 2 liberals and Sotomayor and Kagan and 1 other conservative and Coney Barrett, and then one where Thomas actually signs a dissent with the 3 liberals. Those are the most interesting, I think, of the 4 person dissenting coalitions, but we've got 9 of them total where in fact you've got liberals and conservatives coming together and saying, we don't like what the majority is doing. And so specifically 7 out of the 9 decisions have these odd-based crossed, if you will, ideological line coalitions suggesting that they don't like what the majority has done. And that just really puts into context this idea for you all. And I think for scholars and court pundits alike, that while there was major concern that the really hard and fast or maybe written in stone conservative majority would be unbeatable, that seems this term, at least so far until these final 8 cases come out in the next week, seems not to be the case. So I just wanted to give you some data so that you can get some context about what is going on with the court. And now let me talk about the major cases that the court has decided with that caveat so far. And I'll give you the cases that it has not yet decided towards the end of this talk. But the cases that I really wanted to talk about I'll begin with freedom of speech. 2 slides, and the first is freedom of speech and big tech. And the first decision that I'll talk about is Twitter versus Tomne. And this is one of those 9-0 decisions. This was easy for the court. This was a case about Twitter, which was the named defendant in this case, and other platforms, if you will, if you're thinking Google or Instagram or Facebook, these platforms that put content up on the web. The question is whether or not they are liable for content that is put onto those platforms, and whether or not they need to take what was argued in the case, meaningful and aggressive action to prevent folks, in this case, terrorists, from using their platforms in order to push information, which might, in this case, help recruit people to those terrorist groups, and then ultimately have those terrorist groups create terrorist acts that end up harming people. In this case, the court said, no, Twitter didn't knowingly provide assistance. And that was the argument, that Twitter was essentially complicit, if you will, in terrorist acts that killed people. And the court says, no, that is simply not the case. And in fact, if you go back to the oral arguments, Seth Waxman, who was the Solicitor General under President Clinton, made this argument. And he said, and I'll quote him directly, think about it this way. The people who made the flight simulators on which September 11th terrorists trained didn't know that the Twin Towers were the target of the attack to be held liable. It would be enough, Waxman went on, and he said, if manufacturers knew that the terrorists planned to use the simulators for a terrorist attack, that might be enough. But if they don't know that they're using the flight simulators for a terrorist attack, you can't hold them liable. And it would be the same case here with people putting content up on Twitter. On the other hand, Justice Kagan said, in fact, we have a law that suggests this already, and that is law that governs monetary policy in banks. In fact, she said at oral argument, quote, if a bank could be sued under the Anti-Terrorism Act, why is Twitter different? Social media platforms provide important services to terrorists too, just like banks. The court didn't buy that argument, and the court ultimately said that Twitter cannot be held liable. This really was a case for the big tech companies, where they really worried that the internet could be, if you will, ended, at least in the way that we know of the internet today, for the simple reason that if you hold these folks liable and they can be sued for any content that is up there, they're probably no longer financially able to continue as businesses. Now, in a companion case, Gonzalez versus Google, the court did decide this as per curiam. Per curiam is the fancy Latin term for saying by the court. It wasn't a decision that was signed by anybody. It was just signed by the court. Here, the court simply said on a technical issue, we're going to actually throw this case back to the lower courts. But for all intents and purposes, it ended Gonzalez's case. One point about this case, though, is this case goes back to 1996, really the infancy of the internet and the first time that the justices dealt with an internet case, and they were dealing with a law passed by Congress, the Internet Decency Act, which was meant to specifically protect kids from not terrorist activities, but from pornography on the internet. And there was a section called Section 230 that basically was meant to protect internet platforms from these types of lawsuits. The court ends up not touching the Section 230 claim, and they simply sent the case back to the lower court. But as I said, and as I've got on the PowerPoint, Gonzalez's case is pretty much dead here, and it will probably not come back. But those are highly important cases because the internet is all pervasive in our lives these days. And realistically, I think the court saw the handwriting on the wall that this could really damage the internet and wanted to make sure that those platforms were not held liable. And that wasn't, again, an ideological split. That Twitter case was decided 9-0. Now, there's 2 other freedom of speech cases that come out that are relatively important, although in fact they seem like they may be very trite issues. The first is Jack Daniels versus VIP Products. This is an interesting case because VIP Products makes products for puppies, or for dogs. If you own a dog, maybe you have bought toys from VIP Products. They make products that parody real products. Jack Daniels got angry. If you drink Jack Daniels, you will know that Jack Daniels is called Old Number 7. And VIP Products made a dog chew toy that looked just like a Jack Daniels bottle, but it actually called itself Old Number 2. seemingly a reference to dog excrement, if you will. And they were just parodying Jack Daniels. And Jack Daniels said, look, we understand parodies. And in fact, if you go all the way back to the Rehnquist court in the late 1990s in a case called Hustler Magazine versus Jerry Falwell, where Hustler Magazine had parodied something pretty obnoxious about the Reverend Jerry Falwell, and Hustler Magazine won, and the Supreme Court, in a decision written by Chief Justice Rehnquist at the time, said parody is one of the key features of freedom of speech, and we need to allow parody to be part of our public discourse. In this case, the Supreme Court disagreed, and again, unanimously. The justices said parody is one thing, but if you go so far as to make it seem as though you are fully infringing on a trademark, that actually does not receive First Amendment protection. And in this case, if you were to Google, and I should have put pictures up here, but I didn't. If you were to Google a bottle of Jack Daniels and then a bottle of this dog chew toy of Old Number 2, you would know that they look so similar that it probably infringes on Jack Daniels' trademark. Again, an easy case for the court. Another, and this would actually be the fourth case that implicates Minnesota, and I don't have it on my Minnesota slide at the end of this, but the Warhol Foundation versus Goldsmith implicates Minnesota because this case is about a photograph and a reproduction of our beloved Prince here in Minnesota. And the Warhol Foundation, obviously Andy Warhol has been dead for quite some time, but the foundation recreated a photo that had been taken of Prince by Goldsmith, and shortly after Prince's death had recreated that photo for Vanity Fair. And the argument that Goldsmith made was, in fact, that wasn't fair use. There wasn't permission given. There were not royalties given. You simply, for all intents and purposes, stole this image, recreated it slightly differently. So it's on sort of not looking like a photograph anymore, but it looks like an image of the photograph. That is not protected speech either. And the court actually ruled against the Warhol Foundation. And I think there were many commentators, if you go back and read about this case, who thought that the Warhol Foundation might be able to pull out a win in this case. But by a 7-2 margin, the justices said that is not the way that we're going to go. We're going to continue to protect trademarks in the United States. So those are the free speech cases so far. So let me head to the Native American cases. And you'll note here on the top of the slide that there's a loss and a win. And it seems as though tribal nations have been winning quite a bit at the U.S. Supreme Court in recent terms, in particular since Justice Neil Gorsuch got on the bench. He's from the 10th Circuit. He probably understands tribal law and tribal treaty law more than anyone who has sat on the U.S. Supreme Court. I would say in modern times, possibly ever, as well is one possibility. And he is very much, at least the way that he reads treaties with Native tribes, using his originalist viewpoint or his originalist glasses, if you will, has been a pretty hardcore proponent, if you will, of enforcing very strongly tribal law and tribal treaties in the United States. But let me first talk about the loss. And that first loss is in Arizona versus Navajo Nation. And this is one of the 5-4 decisions. And it is a decision where you get a split of the conservative majority. Justice Kavanaugh writes the opinion for the majority in this case, and Justice Gorsuch writes the dissent. This is a pretty easy case. It's a jurisdictional case that specifically is discussing whether or not the court, that is the U.S. Supreme Court, under its original jurisdiction, holds all jurisdiction, or if you will, the only jurisdiction to decide who has access to the lower basin of the Colorado River, which is incredibly important with water becoming an increasingly finite resource and an increasingly difficult resource to get your hands on in the United States, especially in the southwestern part of the United States. You have California and Nevada, Colorado, Arizona, all arguing over who has rights to those, or has those water rights. And then you've got the Navajo Nation who says, well, we've got a treaty from 1868 that says we also have rights to these waters. And we want the US government to tell us what rights we have and how far those rights extend. In other words, tell us how much water we get out of the Colorado River Basin compared to all of the states around us. And the court says in the decision written by Justice Kavanaugh, these are the court's words, not mine. The court has, quote, no affirmative duty to the Navajo Nation to help you secure water. The treaty just says you've got the water, but the federal government doesn't need the next step to make sure you can help actually get that water for the people who still live on tribal land. Now, the interesting thing in this case is Gorsuch. Go back and read his dissent. It's very short. And in fact, Kavanaugh's majority is very short as well. It's only 13 pages. Gorsuch's dissent is slightly small or shorter than that. And he eviscerates Kavanaugh, if you will. And his evisceration comes down to one line. And that is, he says, this is a really simple question, period. And that question is, if the Navajo Nation has access to the law, or to the water, and the federal government is supposed to give it access, then the federal government damn well better tell it how much access it has. And so Gorsuch was pretty angry at the court not doing this. And this was sort of a setback because Gorsuch had really been pushing forward protections for tribal nations, First Nations in the United States, but this was a loss. But there was a win for tribal nations. And this is Holland versus Bracken. I'm sure I'm butchering that name, but this case decided 8-1 deals with the Indian Child Welfare Act. And yes, the court, despite it being politically incorrect, continues to call these cases Indian cases. It has done so since time immemorial, and it's still dealing with a law that was called the Indian Child Welfare Act. And the ICWA, which was passed in 1978, said this: we are going to try to make sure that if kids, children of tribes become orphans, or if they need to be removed from their homes, that they are actually going to be placed above anyone else with tribal families, with Native American families, if you will. And the court says in this case, we're going to uphold that law. The argument in the case on the other side was simply that it makes no sense to say that we're going to affirmatively promote keeping children with Native families when those families might not have the capacity to care for them any better than their blood relatives are able to care for them. And the court said, no. The law in 1978 passes constitutional muster, and we are going to make sure that we keep Native American children with Native families, if at all humanly possible. So a win and a loss for tribal nations in the United States. The court did and will again next term deal with the American with Disabilities Act. And in this case, a case Perez versus Sturgis, another one of those, if you will, easy cases for the justices where the facts were so egregious that it seemed as though it was easy for the justices to say the ADA has actually been violated. This is a case, Miguel Perez, 23 years old. He was a student who is deaf from the state of Michigan. The school had assigned him a classroom aide, except that that classroom aide was not, or did not have the ability to sign. In other words, was not trained to deal with deaf students. And shortly before Perez is going to graduate, the school district comes to him and says to his parents, your son doesn't qualify for graduation because he didn't do well enough in his classes. And his parents sued. And I suppose most of us would have as well, because if he doesn't have an aide who can actually help him do well in those classes because he can't understand what is going on because he can't hear, that is a violation of his rights under the ADA. Now, what is interesting is the Perez family sued under two different laws. One was the American with Disabilities Act. The other was the Individuals with Disabilities Education Act, or the IDEA Act. And the argument was that, or the argument that was made by Sturgis School District was that Perez had to exhaust all his remedies under the IDEA Act before he could sue under the ADA. And by this 9-0 decision, the court said no. The court said you can sue under both. And even if, as was the case here, there was a settlement made under the IDEA Act, the Perez family and everyone else going forward can still sue under the ADA as well. So you can take two lines of lawsuits to make sure that you are protected if you are someone in the United States with disabilities and you are trying to make sure that you get an appropriate education in this nation. Now, this might be considered one of the more boring topics, if you will. I go from free speech to tribal law to the Americans with Disabilities Act to executive agency power. But in fact, this case, specifically Sakic versus the Environmental Protection Agency, and you get a 5-4 decision. And I say sort of because in the end, the justices all agree sort of on the outcome of this case, but they disagree with all of the rationale. And so there really are such a conglomeration of opinions that it is ultimately viewed by legal scholars and court scholars as a 5-4 decision. And this case is about how far the Clean Water Act extends. And when the Clean Water Act was passed in the Nixon administration in 1973, it actually said specifically that the Clean Water Act applies to what is known as, quote, the waters of the United States. By 1980, that definition was increased to what became, quote, all waters that could affect interstate or foreign commerce. That means almost any waters. That is whether they're navigable, that is a lake or a stream or a pond or a river, and unnavigable waters. Those of us who live around wetlands would know that we can see that waters are swampy. We can see that they're wetlands, but unlike maybe the Everglades, not all wetlands are navigable. The court here took a very specific view, an originalist view, if you will, or a plain meaning view, when it said, unless Congress changes the definition of the waters of the United States, the only waters that are controlled by the Clean Water Act are those that are navigable. That is the read of the court in an opinion written by Justice Alito, and he says that's all that can be regulated by Congress unless Congress changes its charge to the EPA. And this is why I talk about this case in terms of executive power instead of environmental protection, because there is this interplay between Congress passing a law and then executive agencies carrying out those laws, but how much discretion those executive agencies might have. And this case, while it has two effects. One is it's going to make it significantly easier for dumping to happen in wetlands, which if you know anything about the environment, and I know very little except for what I read about it, that water from wetlands can bleed into navigable waters, okay? But that sort of dumping is not protected by the Clean Water Act anymore. On the other hand, what this also does, and this is the second impact of this decision, is it severely limits executive power discretion unless Congress gives explicit mandates as to how a law should be carried out. And we know that Congress doesn't work very quickly. We know it's very difficult, and especially in this day and age of gridlock in Congress to pass laws. And this leaves not only the EPA, but many other, if not all, executive agencies wondering what power they will have going on in the future. And again, and I've said this before, time will tell, and time will tell how the court will push this case further or pull it back in future terms. Now to perhaps one of the top 3 or top 5 most important cases decided this term, and that is the Voting Rights Act and redistricting. And this case comes out of Alabama, Allen versus Milligan. And this was a 5-4 decision that I think everyone and their brother, sister, aunt, and uncle, grandma, and grandfather thought would be a 6-3 decision in favor of striking Section 2 of the Voting Rights Act. We saw this happen in Shelby County with Section 5, and then some cutting back of Section 2, although Chief Justice Roberts said in his opinion in Shelby County that Section 2 could still be used. But for all intents and purposes, with Shelby County and then some cases that happened after Shelby County, the Voting Rights Act was really on its last breath, if you will. It was on its deathbed, and everybody assumed that this case, Allen versus Milligan, would be the final blow to the Voting Rights Act. And that's not what happened. Chief Justice Roberts, Justice Kavanaugh joined Justices Kagan, Sotomayor, and Jackson and said, no. The way that Alabama drew or gerrymandered its districts fundamentally violates Section 2 of the Voting Rights Act. And Section 2 of the Voting Rights Act says specifically, you cannot discriminate racially when it comes to drawing voting lines or when it comes to voting policies more generally. And that 5-person majority, for all intents and purposes, saved the Voting Rights Act and saved the ability of folks to sue under Section 2 if they believe that they have been discriminated against. In this case, the argument was that as many African Americans as humanly possible, when the new district lines were drawn, were packed into one district, and therefore there would be only one majority African American district, and African Americans would therefore only have a good shot at putting one African American representative in the House from Alabama, and that's it. When in fact, there probably should be, given the way the population of Alabama is seated, probably have been at least 2. And the majority said there is no serious dispute in this case that there was discrimination. And so this is one of those cases where, very similar, I think, to the Obamacare case decided a decade ago now, just about a decade ago, or over a decade ago now, where everybody says, wow, that was one that we didn't expect. This is probably, at least so far, the most unexpected decision that the 9 have handed down. And then today, before I get to the Minnesota cases and finish up here to take questions for the rest of our time, was another one where people, I think, were really worried about what would happen, and that is the independent state legislature theory. And this is a theory that is based on an obscure reading by some legal scholars that has been sort of pushed around for the past couple of decades, of Article 1, Section 4, Clause 1 of the Constitution. And now, not to bore you too much, but let me read you that clause. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. Now, those who believe in the independent state legislature theory suggest that those words that I just read you, and you can Google them yourselves so that you can read them again, suggest that only state legislatures can change voting laws. And what it does is keep out state courts, and specifically state Supreme Courts, and then most specifically the United States Supreme Court, from getting in the legislature's business. And so if the legislature actually wants to say that in the state of Minnesota, there will be one polling location, it will be in the middle of Target Field, and whether you live in Moorhead, or you live in Waseca, or you live in Winona, or you live on the Iron Range, or in the Twin Cities, you're going to go and vote at that one polling location, and that polling location will actually only have one voting machine. So all 5 million people in Minnesota, and there's probably more like 3.5 million eligible voters or something to that effect, I don't know the exact number, have to vote at that one place. And the argument is nobody can sue because courts cannot get involved. And if this was the case, it was going to be very difficult for Democrats to ever again win in many, many states in the United States. This was seen as a way to guarantee that voter suppression laws, which are more generally seen happening in south of the Mason-Dixon, would be able to stand as law. And it turns out in Moore, and I left out the E there, I apologize. I added this one quickly right at the end because the court decided it right about 9:45 this morning. In Moore versus Harper, a 6-3 decision, the court says, no. Yes, the state legislature can create districts. Yes, state legislatures can decide the manner of elections and where there are elections, but the clause of Article 1, Section 4 does not stop lawsuits, and specifically does not stop the court or state courts from invoking judicial review. And in fact, in the first page of the court's decision, it cites Marbury versus Madison, where John Marshall says in 1803, it is emphatically the province of the judicial department to say what is the law. In other words, legislatures pass the law, and then it's the court system, whether it's state courts or the federal court, in this case both, that determines whether or not those laws are constitutional. This was a huge win for voting rights advocates, and it goes along with the decision in the Alabama case in Milligan, And it also really suggests that the court is not going to buy into this idea that, in particular, state legislatures are all powerful when it comes to election laws and election rules. So again, today, not one of the major cases that I'll show you in a couple of slides from now as I finish up, but it is one of the most important cases to come down this term. Now, what about cases related to Minnesota? Beyond the Prince case, beyond Prince being part of the Warhol Foundation case, there are three cases that implicated Minnesota. The first was Hennepin Tyler versus Hennepin County. And this case deals with the takings clause under the Fifth Amendment. The takings clause says very simply that the government cannot take your property without just compensation, right? So they can't come in and say, we need to build a road where your farm is, and the only thing we're going to do is help you relocate and give you $1. That's not how the court has ever interpreted the takings clause. You have to give just compensation. And so fair market value says that that farm is actually worth $2.5 million, then the government is going to have to give you $2.5 million. They can still make you move because they need to build that highway, but they need to give you just compensation to it. In this case, we're not talking about the government taking property to build a road. In this case, Ms. Tyler had massive amounts of back taxes on a condominium in Minneapolis. She moved out of the house, out of the condo, but never sold it and never paid those back taxes. So the state swooped in, took the house, which it can do under the takings clause, gave her what it said was going to be fair compensation, and it took back the taxes that it owed. In fact, they didn't give her anything. What they did was take money. They took out what she owed in back taxes. It was something like $12,000. Don't quote me on that. You can look at the facts of the case. But then it kept all of the profits from the house as well. In other words, the court had, or the state of Minnesota or the Hennepin County had, for all intents and purposes, taken a surplus that was considered a taking, and the court said unconstitutional, 9-0. This was something that all the justices could agree on, and Ms. Tyler is going to end up getting all of her money back, probably at this point with interest, from Hennepin County. Now, we also have the Holland case. I've already discussed that in the previous slide. This was actually a case about a Minnesota tribe and a Minnesota tribe and tribal families suing under the Indian Child Welfare Act. And so that implicates Minnesota. And then finally, and I'm not going to talk much about this because it's a very technical case, it's the Mall of America case. And this is MOAC Mall Holdings versus Transform Holdco. MOAC Mall Holdings is the Mall of America. Transform Holdco LLC is actually the company that Sears sold to when it went bankrupt. And the court in this case, by 9-0 decision, a very technical case. Again, I don't want to talk very much about because I am not a bankruptcy law expert in any way, shape, or form. That's a little hint that I would love not to take many questions, if any questions, on this case. But then, in fact, the Mall of America does win the case. And the policy implication for this case is, in fact, that federal courts do have the ability to deal with bankruptcy cases. But just so that we're all clear, Minnesota is in the news again and again, and we love our home state, and it took center stage 3 cases, which is a pretty decent percentage of cases to emanate out of Minnesota for the court's 2022 term. Now, what haven't we decided yet? We haven't decided, or the justices haven't decided, the affirmative action cases coming out of Harvard and University of North Carolina. Again, many people fundamentally believe that affirmative action is dead, that Fisher and Grutter versus Bollinger will be overturned. But again, given what has happened with the odd coalition so far, who knows what's going to happen either Thursday, Friday, or Monday, or some combination of those days. President Biden's student loan forgiveness cases have not yet been decided. I would imagine that the justices will throw these cases out as moot because there was a deal reached with the debt ceiling deal in Congress, and student loan payment stoppage is going to end August 31st. The only cut against my argument here about the justices deciding that this case is moot is, in fact, that they haven't handed it down yet, and it would have been easy for them to have done so already. So maybe they're making some arguments about executive power. They're going to decide religion and gay rights. And again, this is akin to the Cake Baker case from several terms ago now. This time it is actually a website developer who does not want to develop websites for same-sex couples who are getting married. And the other side of that is that sort of discrimination is very akin to companies and businesses that used to say they would not deal with people of color. And so it's going to be interesting to see how the court comes down on this side. Again, we can make predictions, and you can in your mind as well how we expect the court to come down. And then finally, religious employees. And in this case, the court's going to decide whether or not employers have to accommodate workers' religious practices. In this case, it's a postal worker who didn't want to work on Sundays. If you all know, it seems odd because we thought we were going to have postal service cut back over the past decade, and now we see postal trucks in the neighborhood even on Sundays. This is a worker who, for religious reasons, says that they do not want to work on Sundays. The precedent in this case is incredibly clear. The court has said that that's not a choice that you should force anyone to make. I fully expect the employee in this case probably to win. But there's 8 cases left. Those are the 4 highly controversial, most major cases that are left on the court's docket. And before I finish up here, so we have right about 45 minutes for questions and answers, is what's to come next term. Next term, you can expect to see another ADA case coming to the court, and this is specific about information on accessibility for businesses. Again, we're going to get redistricting. This time it is in the form of lines drawn by the South Carolina legislature. We're going to get a separation of powers question, which the court hasn't dealt with, although it has tangentially in recent terms. And this is when members of Congress are asking for information from executive agencies, and the executive agency doesn't provide that information or doesn't do so willingly, can the members of Congress actually sue in federal court to get that information? The court is going to deal once again, as it has for the past, it seems almost every term, and it hasn't done so yet, overturning the Chevron doctrine. And the Chevron doctrine is sort of insider baseball, but this is all about what I talked about a couple of minutes ago about Congress delegating power to executive agencies and what that will mean for the power of the presidency going forward. So when it deals with this, that is one of the major cases. And then finally, it is going to deal with freedom of speech, and specifically one that is very dear to my heart, to be particularly honest, and that is if you're an elected official and you have a Twitter account or a Facebook account and it is open, it is not your private account, it is your account as an elected official where you provide information to your constituents, and constituents start criticizing you, can you ban them from those accounts? Or because it's your official account, do you have to allow those critics to be able to be on those platforms? So those are 5 cases that are so far docketed for next term. It looks like the court will continue to decide a pretty decent number of controversial issues. And time, for the third time I'll say it, time is going to tell how strongly that 6-person conservative majority is going to hold up as they work with one another to continue to push a particular agenda in the United States Supreme Court. I appreciate your time. I will stop sharing and I will take any and all questions that you might have. I appreciate it.
Okay, thank you very much, Professor Timothy Johnson. And now it's the turn of the audience. I see that we have one question in the Q&A line, but we have time and room for many, many more. So if you have a question for Professor Johnson, type it into the Q&A line and I will read it. While we're waiting for questions to come in, I'm going to ask a question of my own. There was a really interesting article in today's New York Times in which perhaps many people in the audience saw it. What they did is they showed, first of all, the national polling sentiment on particular issues. And then they showed, in the case of cases that had already been decided, whether the Supreme Court followed the or was in agreement with national sentiment. And I was struck by the fact that, in contrast to last year, when the Dobbs decision was very unpopular among American voters in general, the decisions that they've put forth so far this year seem to be, reasonably popular, in the sense that Americans come down on the side of the courts. So my question about all this is this an accident, or does the court in some underground way listen to the voice of the people?
So look, Judy, that is a tremendous question. And every time I get this question, I give a very similar answer, and I jump back to the 1950s. And in the early to mid 1950s, the court did the absolute unthinkable. And that was, it protected the rights of African-American children to integrate in schools with white children. God forbid that that was going to happen, right? And at the same time, the justices were protecting another minority group, that of the ye old Communist Party or the Socialist Party. And so you get Brown in 54, and you get some decisions in 55 and 56 and 57 protecting commies, if you will, right? That's the pejorative that we were using for them in that day and even thereafter, and maybe even today. And by the late 1950s, the Warren Court, the liberal Warren Court, and it had not gotten to the height of its liberalism, right, in 64, 65, 66, 67 yet, the court retrenched and sort of backed off. And it didn't back off racial integration, but it backed off protecting communists or avowed communists in the United States and their free speech rights, or their rights not to be brought before the House Un-American Activities Committee or the Senate House or the Senate Un-American Activities Committee. In other words, one of the theories is the justices corrected. I think that at least a contingent of the justices, two most likely, and sometimes three, you see it in one of the cases, are making that correction. And those justices are the Chief Justice, Justice Kavanaugh, and Justice Coney Barrett. And sometimes you replace Coney Barrett, if there's going to be a 6-3 decision, with Justice Neil Gorsuch, right? Like in some of those tribal rights cases. And then you're sitting out on the edge with Justices Thomas and Alito and maybe one other. And I think while folks have called this, and I myself have called it, I said it in this forum last year when I did talk about Dobbs and Roe, because that's when it was decided, that this is the Thomas court, not the Roberts court. And what you're seeing here is Chief Justice Roberts trying to reel back in the court. And I really liked that article as well, Judy. I'm not always a believer that public opinion affects the court, because there's no direct, right? There's correlation, but there's no causation because the justices are not elected. But I think what you point out here is absolutely right. And it's the middle of the court, and the middle of the court, like it or not, is the Chief Justice Kavanaugh and Coney Barrett. They are the most moderate of the conservative majority, and they seem to be joining with 2 or 3 of the liberals in more cases than we saw the past couple of terms, and saying, we have all these issues we need to face. We're facing a legitimacy crisis. We need to make sure that we do something about it. Now, it's also that they see maybe the law is telling them to go in a particular direction, but I would be remiss if I didn't say I think that public opinion absolutely has something to do about it. That's a wonderful question.
Okay. All right. Well, let's turn to the questions in the Q&A line. And the first one, I think, is addressing somewhat the same issue. This person says, can you speak to the consistency of decisions of this current court? In some cases, they are following the strict wording of the Constitution, others following existing law. Some decisions follow precedent, the Voting Rights Act. Others ignore significant precedent, in the case of Dobbs overturning Roe v. Wade. Some decisions follow a more liberal agenda, others follow a more conservative agenda. And I think the questioner's point is the same justices vote not necessarily the same ways each time. So could you address that?
Absolutely.
Is it a matter of personality, or is it legal philosophy that governs their vacillation, if you could call it vacillation?
Sure. So it's actually a matter of ideology, right? So as a political scientist, right, I have a courtesy appointment in the law school. I write for law reviews, but I am a political scientist at heart. And the way that I was trained, and I'll be frank about this, I'm not arrogant about many things. And I'm probably not being arrogant about this, but I do think I'm right about this. Justices on the Supreme Court are political actors. Now, you will notice I didn't say they're politicians, because I don't believe they're politicians, but they are political actors who have policy preferences that they would like to see written into law. And I spent lecture after lecture in graduate seminars and undergraduate seminars talking about this particular theory, and the data actually back up this theory pretty well. And so what happens is this. I've got a majority coalition. I'm just going to look at the question here, and I'll pick out the Voting Rights Act versus reproductive rights. And my policy preference on the Voting Rights Act is X, but I also know that I have to satisfy other people in the majority. And so in order to satisfy them, sometimes I might have to cite precedent. Sometimes I might need to cite the plain meaning of the words. Sometimes I might need to cite the original interpretation of the Constitution in order to get the outcome that I want. In other words, these people on the Supreme Court, just like any other political actor, have policies in their sites that they would like to see etched into law. And the path to get to those policies are not always the same. Okay. And so that's how they use different types of rationale. And I think that this questioner is right. It doesn't seem consistent. We would like the justices to be consistent. They are not always, but what we ultimately see is the end result, and that is simply who wins and who loses. Great question.
What you're saying in essence is that, yes, many of the justices do have an agenda, hidden agenda, or maybe not so hidden. But I think in decades past, 50 years ago, most Americans felt that the justices came at each case fresh, but without tendentious tendencies. They weren't trying to promote a specific ideology. Is that true, that what I've stated, or did they always have hidden agendas? We just know more about it now.
Yeah, so I would not use the word hidden. I would say agendas. They've always had agendas.
Okay, yeah.
We always knew that Hugo Black was a huge proponent of free speech. In fact, Black believed that nothing should be banned. Think about, the worst things that you could say to someone in terms of hate speech or pornography or whatever it might be. Black said, look, if it comes out of your mouth or it comes on pen and paper, in this day and age, he would say if it's typed on a computer, it's protected speech. He had an agenda on freedom of speech. Justice Thurgood Marshall had an agenda on racial policy in the United States, right? And you can go even all the way down to tax law and antitrust law. All the justices have preferences about what they would like to see the law said. Today, I think we, as American citizens and as scholars and court watchers, project the ideology onto the justices more than they would project it on themselves. If I lined them all up on this Zoom call right now, they would all say, nope, Judy, Tim, you're wrong. It's all about the law. And they would say it actually not like they thought they were lying to you. They would say it with a straight face because that is what they believe, because that's how they're supposed to act. But the data are just too clear. That there are agenda behind what justices do, all the way back to John Marshall having his fight with Thomas Jefferson in Marbury versus Madison.
Okay. All right. We have several questions actually about the ethical issues. Clarence Thomas and friends, and very well-connected friends, and apparently so does Alito. How does that affect the credibility of the court in general? How does that affect? Does it affect our dealings with each other? What would you like to say about those issues?
Yeah, so I would say that certainly, as I mentioned a little while ago, that the court has the biggest legitimacy crisis it's had in its history. It probably had a pretty, actually not probably, it had a pretty big legitimacy crisis when Chief Justice Taney said prior to the Civil War that if you had been a slave, you're an object and you will never be a human being and ergo never a citizen in the United States. It probably had a legitimacy crisis when it fought with FDR. During the New Deal or prior to the New Deal era, right during the Depression. This is the biggest legitimacy crisis the court has ever had. Because remember, even though I made the claim a couple of minutes ago that justices are political actors, I'll say it again, I don't believe they're politicians. The problem is that it seems as though justices are acting like politicians. Now, we expect, although we don't like it, but we expect members of Congress to be wined and dined, if you will. We do not expect our jurists who are supposed to be above the political fray to be wined and dined. They might have policy preferences, and I will go to my grave making that argument, but they're not supposed to be, as we see most recently, being taken on trips to Alaska where the resort is $1,000 a night per room. Whether or not that's true or not, right? That's the allegation. We've seen pictures of it. They're not supposed to be doing that. I think the ethics charges or allegations against justices Thomas and Alito, and then a little bit on Gorsuch, although it's been quiet, a little bit on the chief and his wife, although it's been quieter, are going to continue to haunt the court for some time to come. I think that may be one of the reasons the middle of the court is really trying to moderate itself by leaning a little bit more left this term than maybe we would have expected it to have done. As for the other question about this, which asks about Congress passing legislation, sure, actually, there's a bipartisan effort to do so, to be perfectly honest. And what the Supreme Court will do is it will cross its fingers and it will hope that somebody sues and says that's a violation of the separation of powers. That case will come to the court. And I can almost guarantee you, if I were a betting person, and I guess I am sometimes, but if I wanted to bet on this, I would bet millions of dollars if I had them, that the court would decide 9-0 that Congress can't tell the court how to run itself internally. And the justices will go to their graves, whether it's the 9 we currently have or 9 that will exist in 2090 or 2190, will go to their graves saying, you can't tell us what to do internally. So it's just, Congress can pass it. I just don't think the justices will listen to it.
In terms of ethics issues so far, we've talked mostly about expensive gifts, expensive vacations and so on. But here's a questioner who wants to know, how can Clarence Thomas still be on the court with such clear conflict of interest regarding his wife's political activities? He is clearly not willing to police himself. Would you want to comment about that?
Yeah.
Do Supreme Court justices recuse themselves routinely? And why is Clarence Thomas not doing them in certain cases?
Yeah, so let me take the larger question first, Judith. Judy, I'm sorry. I go back and forth. I'll make sure.
No, sorry. I don't mean to knock you off of your chair.
I go between Tim and Timothy. It depends on the situation within I find myself. Look, there's only one way to get, there's 3 ways to get a justice off the Supreme Court. One of them is very macabre. They die. The second is they retire. The third is impeachment. Those are the only ways to get a justice off the United States Supreme Court. And you all know, you're in this room, right? There's 160 some of us in this room. I know you all are very bright people because and care about the Supreme Court and politics, because otherwise, why would you be here on a Tuesday afternoon when it's so beautiful as I look out my window? Impeachment's not going to happen. Why? Because the Republicans control the House and it's the House who impeaches. Now, if there were some way that you could get the number of House members in the Republican Party to agree with the Democrats and put a coalition together and get Justice Thomas impeached, maybe he loses in the Senate because the Democrats control, but probably not, because you need 2/3 for conviction. So that's not going to happen. So how can he still be on the court? It's because the only person who can decide whether he gets off the court is himself. Now let's take, Judy, your second issue, and that is recusal. Justices, in terms of the internal ethics part of the court, justices also are the only ones to make the decision about whether or not to recuse. And here's what I mean by that. Each individual justice will determine whether to recuse. So let me take up the issue by talking not about a justice who's currently on the bench, but 2 different justices who are no longer with us. And I'll begin with Justice Scalia. So there's a contrast. So when the case came to the court during the Bush administration suing Vice President Cheney because the Sierra Club wanted to have accounts of the meetings that the vice president had with big oil and other big energy companies as the Bush administration was deciding what energy policy to forward. That case came all the way to the U.S. Supreme Court. And prior to that term beginning, Justice Scalia went duck hunting with the vice president. And Scalia came back and said, really what Justice Alito said. I mean, really, you don't think that I can't figure out that duck hunting is different than deciding this case? And he decided, of course, he voted in the vice president's favor, but he said very clearly and very publicly, I can figure out the difference. Very close to that term, and I forget the exact term, but a religious freedom case came to the court. And prior to that term, August before that term began, Scalia gave a scathing speech, I believe at Liberty University, but I could be wrong on exactly which university, about this specific issue. And when the case came to the court, Scalia said, I should probably recuse myself because I gave this public speech, which sort of outed what my views are. I can't be objective anymore, so I'll recuse. So that's one example. And so Scalia took the hardcore tack that Thomas and Alito have said, we don't really need to recuse. But then in other cases, at least in one other case, he said he could. And then I'll give you the one hard and fast rule the justices have for recusal. And that is, if you have a financial stake in a case, then you recuse. So any case where former Justice Ginsburg's husband's law firm came to the court, she recused because she had a financial stake. If his law firm won, they'd make more money, and therefore she'd have more money in her bank account as well. So she'd recuse. And then my favorite example probably comes from Lewis Powell, Nixon appointee in the early 1970s. And when the famous baseball case, the Curt Flood case, came to the US Supreme Court, where Curt Flood sued to try to get free agency instilled, Powell sent a memo around to his colleagues and said, I need to recuse in this case because I own stock in Anheuser-Busch. Well, at the time, what did Anheuser-Busch own? It owned the St. Louis Cardinals, and Curt Flood played for the St. Louis Cardinals. And whichever way it happened, there was going to be a financial gain or loss in Powell's pocket. And he said, I can't decide this case. Bottom line, however, only the individual justice decides whether they recuse from a case. And until there's a different rule where the other 8 can maybe vote on it, they're just going to decide what they want to decide.
I remember an ethics case from long ago when I was a kid, but I bet many in the audience do as well. Justice Abe Fortas was forced off the court in the 1960s at a time when the Democrats controlled the White House and both houses of Congress, and he himself had been appointed, I think, by President Johnson. How come that could happen then and could never happen today? And did it have something to do with how egregious his offenses were? I don't remember what his offenses were, but could you talk about that?
Absolutely. So if you go back and it's either slate.com or Adam Liptak. I actually think it was Slate has an article about this when the Thomas allegations initially came out. What pushed Justice Fortas out were his 8 colleagues. And there is an account of what happened at conference. Because let me add this caveat. What Justice Fortas did was not incredibly egregious, because all the other 8 justices were taking similar or getting similar amounts of money to go and quote unquote teach classes at colleges and or law schools around the country. They were all getting these honoraria. It just so happened that Fortas's went public. So Fortas, if the account is accurate, and I have no reason to believe it's not, comes into conference one day, and the other 8 basically said, yeah, we're all doing the same thing, Abe. You got caught. You need to resign because you're making the court look bad. And today, I think that I think it was a different time. And I don't think, and it's not necessarily a commentary just on Justice Thomas or Justice Alito, although you could take it that way. I don't think that a justice today, especially in the power position that Alito and Thomas are in terms of being really the most powerful 2 justices on the bench right now, are going to succumb to that pressure. Could the Chief Justice cut them out from everything? Sure, but if you cut 2 out of the 7 out, now everyone else has to do more work. And so I'm not one that says that, things were better back in the day. And this was 4 years before I was born, 2.5 years before I was born, that Fortas resigned from the bench. But I do think things were different. And I think that the justices all pointed their fingers at him and said, for the honor of the court, you need to do this. And I just don't think. It
was considered dishonorable for him to accept an honorarium for a talk. I thought, don't the justices do that now all the time?
They do. It's essentially, though, expenses. So they get the new ethics rules. And so note that all of the new monetary and ethics rules that we all think came out of Watergate, right? All the campaign finance reform, a lot of those also came out of the Fortas controversy in the late 60s. So it was sort of part and parcel of the same thing. And so no, now when the U of M Law School brings out a justice, they will be paid reasonably for their expenses. Now they can go and teach classes, right? When they're not in session, we know that Justice Kennedy did for a long time, the Chief Justice still does. They can be paid for teaching law school classes. We're going to have a real problem if they start being paid $1 million per class. But if they're paid, you know, $10, $15, $20,000 a class, most people don't have an issue with this. And here, and I know that I can't answer anything shortly, but I'll say this last thing.
That's right.
The justices all make right around $275,000 a year. That seems like a lot of money. It's just not, because they are considered 9 of the top legal minds in the entire world. All of them would be pulling in 7, if not close to 8 figures if they were in private practice. And so to allow them some, again, we're not going to allow them to take honorary of millions of dollars, but we're going to allow them to take some honorary of some tens of thousands of dollars with the proviso that they report it, and they report it publicly.
I see. Okay. All right. I'm going to skip forward because there are other issues to talk about other than ethics, but I'll just, there's one comment, and I'll just put it forth here. This person says, increasingly, I admire the President of the United States, POTUS. I'm not quite sure what the relevance is, but you know, did you have a comment on that?
Oh, no. If you go down, it was actually a typo. That was a typo.
Oh, excuse me. Okay.
Yep. No, turns
All
out
right.
I scrolled down enough. It was a typo, so I don't have to deal with talking about.
Okay, so it was the person that admired the Supreme Court, perhaps, or well, we'll find out as we come down. All right. With the Alabama case allowing gerrymandering, specifically required by states, and previous cases with the Supreme Court saying that they won't stick their fingers into gerrymandering, what does this bode for the future? Will the Supreme Court ever get involved? Well, I'll let you address that.
I mean, the court frankly got involved in this case and said that the gerrymandered districts were unconstitutional, right? Violated Section 2. This is one of my favorite stories because when the court was dealing just prior to the pandemic, so it was 2018 or 2019, and I forget the gerrymandering case they were dealing with there. One of the media outlets in town, I think it was Carol Levin, wanted to come and talk about gerrymandering with me and these concepts of cracking and packing districts. And my wife and I always have a jar of M&Ms in the house, and it happened to actually have the red, white, and blue ones. It was around the 4th of July. And so they actually asked if we could use those. They spread them out on our wooden dining room table, and we moved them around in red, white, and blue to show you crack and pack districts. I think the bottom line is I think the court will continue to keep its hands on gerrymandering. It will continue to keep its fingers in Voting Rights Act. And given what the court did today, I mean, or this week with the Voting Rights Act, you know, it is the Chief Justice backpedaling, if you will, on what happened in Shelby County. Now, is he going to backpedal enough to fully save the Voting Rights Act when what he said in Shelby County was, we don't really need the Voting Rights Act anymore because discrimination doesn't happen? I think what the chief saw in Allen versus Milligan was, oh my gosh, there's a lot of discrimination, at least in Alabama, that's still going on, and we need to stop it. So I think the court will keep its fingers in this pie for quite a long time, and it might move back and forth, but it's going to continue to take up these issues as it is next term with the South Carolina case.
Okay. It appears, says this questioner, that recent and future cases are very specific to a particular circumstance rather than a broader decision that would encompass a particular subject. For example, Americans with Disabilities Act with different spins. Do you agree with that? What would you say about that?
You know, I think that the justices are always looking for cases with what they would call good facts, where they can decide the individual case, but then also make broader law. So yes, it took an ADA case this term that was very specific to education policy, but they've done that in the past and said, look, these are things that we need to make sure that we protect for people. Now, the case next term in terms of information on the internet and on websites that might be accommodating or not accommodating people with disabilities, I think is going to be, and I've looked at any of the briefs yet, I'm sure they're not fully out yet, but is going to be a confluence of freedom of speech, versus protecting the rights of those who want to be able to use particular facilities. So yes, it does seem as though that there are specific type cases, but let's all remember that every case that comes to the court actually is about two individuals. Somebody feels they've been harmed, whether criminally or civilly, and the other side is the one who is being accused of having caused that harm. Every case that comes to the court is very specific. And then the justices, and this is what appellate courts do, set the law in a much broader context. And so you get a winner and a loser, but then you get a winner and a loser writ large, if you will. Think about the cases that are still there, affirmative action being maybe the best example.
Okay. What do you think is the potential source of discord among conservative members with regard to executive power?
Yeah, this is a phenomenal question, because one of the hallmarks that scholars thought was going to happen with the Roberts Court, and maybe it's because the Roberts Court began during the Bush administration, but one of the hallmarks of the stamps that of the Roberts Court era was going to be that this was a court that believed in strong executive power. Now, those who were the strongest advocates of that, say an O'Connor and a Rehnquist and a Kennedy, and I know Rehnquist had to be before Roberts, but right, he's the last. But then you continue with the O'Connor and the Kennedy are gone. But one of the key issues that this court era really wanted to take up with strong executive power, and they're not showing that anymore. They really are sort of moving back on this idea of making sure that executive power is not as strong as it could be. Now, here is probably the reason why. This court is still a strong advocate of the power of the president. Why? Because the president is elected. What this court is not a friend of is the power of executive agencies. And why? Because bureaucrats are not elected. There are lifetime bureaucrats. I guarantee you there are people working in, you name the alphabet soup, SEC, FCC, EPA, whatever it might be, who worked for, I'll do my numbers, maybe worked in the late Clinton administration, worked for Bush, worked for Obama, worked for Trump, are working for Biden, and are probably getting near retirement, right? Who were life, never elected, gets to help set policy, and you name the area of that particular agency. That's where this court is not a friend of executive power.
Yeah. Given perhaps the decision that just came down, the Moore versus Harper decision, a questioner asked, what role can a state legislature play in determining election law?
Oh, all of it, all of the election law for federal elections still is going to begin and end with the state legislature. But what the court says in this case is what a legislature can't do is start setting up these discriminatory practices. Go back to and I promise you this was off the top of my head, my crazy example that would never ever happen of one voting booth in all of Minnesota, and it's in the middle of Target Field. What the court says is that's a case of such egregious discrimination that we get to hear that case. So legislatures will always be able to set the rules. All the court says in Moore versus Harper is the power of judicial review still says that we get to determine whether or not these are bad practices or specific discriminatory practices.
Okay. All right. If justices have agendas, but they're not willing to answer questions about their agendas during confirmation hearings, how do we select justices in a meaningful way?
It's a great question, right? Yeah, I am so impressed with the questions that you all have today. So thank you so very much. The only thing that would make it better is that if we're interacting face to face. But look, it makes it virtually impossible, right? The fact that, and people call it the Ginsburg rule, that justices will not answer questions about cases that they might decide. That gives short shrift to Justice Sandra Day O'Connor, because it was really the O'Connor rule. Before it was the Ginsburg rule, it was the O'Connor rule. And I think RBG just got famous for it. Justices do not want to be biased, or potential justices don't want to be biased. So they don't want to answer those questions and put themselves in a corner. I think the bottom line is it makes it virtually impossible. It just does. Um, and look, I'll
Mhm.
just give you one example. I'll give you two. Did anybody believe that we would be talking as much about the liberal decisions that Justice Neil Gorsuch is making, especially on
Yes.
tribal law? Nobody thought that was going to
Yes.
happen. And that would not have been sussed out in a confirmation hearing. And
Mhm.
the other is Justice David Souter, who never
Mhm.
really said anything in his confirmation hearings. He never really published any law review articles. He was the ultimate stealth candidate. Turns out he was a lot more liberal than Bush and Governor Sununu
Mhm.
thought he was at the time. So the bottom line is it makes it inherently difficult.
But the last three justices came to their positions because they had been recommended, I understand, by the Federalist Society. Are they turning out to be disappointments to the Federalist Society?
I would say maybe in some respect, right?
Mhm.
Let's drop the million-pound elephant, and that is Dobbs. In that respect, they're not disappointments because they got what the conservative coalition has wanted since 1973, and that is to overturn Roe versus Wade. I think the disappointment will come in this term, and I think you're going to see a lot of consternation from the right where they say, really, did we really get Kavanaugh and Coney Barrett to really moderate themselves? And as the chief, I mean, if you read the most recent biography of the Chief Justice, he's one of the most conservative justices ever to sit on the bench, and he's moderating himself as well.
Yes.
So yes, I would bet, again, going back to being a betting person, in the very near future, at the end of this term, you're going to see some consternation from the right. Now, they've still racked up wins, if you will, for the conservative movement. But yes, I think that I wouldn't go so far as to say full disappointments, but there will be some worry.
All right. Justices, in reality, live, work, move, and interact in a bubble. How would they even know what the American people's attitudes or thoughts on a subject really are in order for them to represent the people?
Excellent question. So I've got an incoming graduate student who is already doing research on this. And the way we do this research is historically using the archives of former justices. And it turns out that a good number, and the best one was Minnesota's own Harry Blackmun, kept lots of news accounts in their papers at the court that then end up in their archives, Blackmun's in particular at the Library of Congress. Look, whatever your ideology is, right? And I don't care what it is, and you don't care what mine is. And yes, we care in terms of the justices because of our own political policy preferences. But these are 9 very smart people. They read the news, they listen to the news. I'll bet there's secretly some of them might be, I won't name who, because I'm not sure who, might be on Twitter. They follow the election returns. It reminds me of Miracle on 34th Street, right? For those of you who remember that movie, one of my favorite holiday movies. And what happens at the end of that movie when the U.S. Postal Service comes in and dumps all the letters?
Right.
You see the judge's buddy wink at him from the crowd because the election returns are coming. They know. They know. The fact that Justice Kagan had cited Taylor Swift in an opinion, the fact that rap lyrics have been cited in opinion, the fact that law review articles and political science papers have been cited in opinions, these folks, along with their clerks, know what's happening outside of the ivory, or the marble palace, right? Their ivory tower or their marble tower. They just do, and they probably do more so than a president does, because the bottom line is they all live pretty real lives, except that they're going to the court every day for work. And so I'm a firm believer that they actually do know what's going on. And if they don't, their clerks make sure that they do.
Okay. Do you think there should be age or term limits for the justices?
You know, I think that's probably a possibility. But I have pause. And I think about Minnesota again. And I think that Alan Page should still be a justice on the Minnesota Supreme Court. Not because I necessarily agree with him ideologically or legally or politically, but he was one of the best minds ever to sit in the Minnesota Supreme Court. And turning 70, which for a lot of people today is still considered middle age, as we're moving further and further into the 21st century, age doesn't mean anything, right? It's just
Mhm.
arbitrary number. We named our son after the famous baseball pitcher Satchel Paige, and Satchel Paige once famously said, age is just a number, right? It doesn't mean anything. And that's not the exact quote, but he means, actually his quote was, how old would you be if you didn't know how old you were? Right.
Right.
And that's really my point. I do think that perhaps term limits might help a little bit in terms of pushing particular agendas. But the other side of that is, if you only sit for 9 years or 18 years or whatever the term limit might be, maybe you push even harder for your particular agenda. What we have now with lifetime tenure is far from perfect. I don't have any reason to believe that term limits or age limits would do any better. And until I see that empirical evidence, I'm willing to stay with what we've got, no matter how imperfect it is.
The next questioner points out an anomaly. There are currently 7 Catholics on the court, and I believe until quite recently, until the Justice Ketanji Brown, is it, joined the court, there were no Protestants. So if the personal convictions of the justices can influence their decisions, she says, is there legitimate concern that perhaps there isn't enough diversity of religious belief? Does that matter?
I mean,
certainly 70% of the United States is not Catholic.
Right. Look, it might matter. The data suggests that it doesn't matter. In fact, there was another, I will say another, and people will scoff at me for this, but Justice Gorsuch is actually a practicing Episcopalian. Even though I think he was raised Catholic. No, you don't have to be sorry, because I think he was raised Catholic. But so we also have an Episcopalian on the bench as well. Look, yeah, I think that there's cause for concern, and people were worried when we had the first Catholic president. Now we've got another Catholic president. The data don't bear it out, right? Maybe in some religious freedom cases, but I mean, if you had 7 Orthodox Jews on the bench, possibly you would have the same argument. So in today's legal world, I'm not necessarily bothered by it. Because there's just not enough opinions or decisions that implicate religion and religiosity, that it's an issue. But I will admit that it is an issue, that it is one way in which the court is not representative of the United States. And it would be much better if we had a court that was more representative in many ways, diversity-wise, of representing this.
In the past, there have been justices, and I'm thinking of Justice Louis Brandeis, for example, who have mostly been in the minority in their own time, but have had tremendous influence in the future going forward. As far as you know, are there any current justices who may be in the minority for their period, but will have that kind of lasting influence in the decades to come?
Yeah, I think Justice Kagan, hands down.
And why?
Look, she is probably hands down the smartest justice on the bench. And I think justices across the board, her 8 colleagues would suggest that's the case. I've said this before, and I think I've said it in this forum before. Her biggest advocate when she was nominated by President Obama to be confirmed was Justice Antonin Scalia. Why? Because Scalia wanted someone who he believed, and Scalia was really, really, really smart. He wanted someone who he thought was at his level. And he already had Ginsburg, but Ginsburg was getting up there in age. He didn't know when she was going to retire. So he wanted someone who could punch him as hard as he punched his colleague. That was Kagan. And I think Kagan writes such smart dissents, such smart concurrences, and also equally just as smart majority opinions when she's able to write majority opinions, being in the minority, that I think her concurrences and dissents are going to have sort of that Brandeisian, that Blackian, that Holmesian, and possibly Douglas type effect for some time. I don't know if any of us will be around to see that effect take place, but she would be my pick for that.
Okay. Yeah. All right. Unfortunately, alas, we are out of time. Thank you so much, Professor Timothy Johnson. This is our final Tuesday Scholar Talk for the season. And I must say for myself, it is my final appearance as moderator of these talks. After more than 4 decades as a librarian, I am retiring. But of all the things I've done in my career, this Tuesday Scholar series has been among the greatest pleasures for me, and I've been honored to be in the company of our speakers. And certainly today's speaker is a great example of why I've been so honored to be among these fabulous speakers. I've been honored to be in the company of my tech colleagues, and most of all, I've been honored to be with you, the audience. Without your lively curiosity, attentive listening, and fantastic questions, there would have been no series. Thank you all so much. And I must also give a shout out to my great colleague, Grayson Simmons, who has been so helpful behind the scenes, also Carmi Blyfus. I look forward to joining all of you in the future. Hopefully there will be more history talks, and I will be a loyal member of the audience. But for today and for now, I will say thank you so much and goodbye.
Thank you, Judy. Congratulations.